Welcome to IP Goes Pop, your source for exploring the interface between intellectual property and pop culture. The IP Goes Pop podcast series is created and produced by Volpe Koenig, an intellectual property law firm based in Philadelphia, Pennsylvania. Visit us at vklaw.com. This program should not be considered legal advice. Please consult an attorney for your specific situation. And now your host, intellectual property attorney, Michael Snyder.
Greetings, cheers, and welcome back to another season of IP Goes Pop, the podcast that explores the connection between intellectual property and pop culture. I am your host, Michael Snyder, back for another year, watching movies, listening to music, watching TV shows, things I'd probably like to do anyway, but now I get to talk about it and tie it into my other love of patents, trademarks, and copyrights. First of all, I want to say to all listeners, Happy New Year. Looking forward to a better 2021. And of course, our disclaimer, this is not legal advice. So if you have a legal question, please consult an attorney. And to set the table a bit, on today's episode, IP Goes Pop goes to the arcade. And here we're talking about the home arcade, which can be Xbox, PlayStation, PC games, to discuss video games and intellectual property. Now, thinking of video games, I want to take you back first to a magical time of arcades filled with coin-operated games, with quarters placed on the tops of cabinets to signal who has the next game, a world of Space Invaders, Missile Commands, and Froggers, and Galagas, one of my favorites. A world where happiness was only an extra life or a free game away. Now, of course, since that time, and they do seem like simpler times, I'm talking about the heyday of arcades in the 1980s, the graphics, some of which were compared to modern day video games. I don't even know if today's kids or teens who play video games would even recognize them as such, other than for some kind of retro quality. But certainly things have come a long way since the days of Pong, where you have many square or rectangular pixels which depict different things. And now we have mapped, green screen depictions of real life people or real life events. And those are today's video games. Now, all video games are protected by intellectual property of some kind or another. The primary way that video games are protected would be like all computer software, which would be through copyright. However, today we're going to see that trademarks play a big part as well in the protection of video games, or at least impact video games in some way. Now, because of this drive to have video games depicted as being real world events or looking like the real world as much as possible, I don't mean MTV's real world, I mean the actual world we live in, they do run into real world intellectual property issues, even though they are virtual video game worlds. The first case I want to talk about today, where truly a real world object or product or thing was depicted in a video game, and that caused intellectual property issue. The case is called AM General LLC versus Activision Blizzard Incorporated. The case is out of the Southern District of New York. In fact, both our cases today are out of the Southern District of New York, and both of our cases are very recent, having taken place in 2020. So this decision came down March 31st, 2020. Now, let's look at the players in this particular real world versus video game world battle. So on one side, we have the Activision, owner of the very famous Call of Duty line of video games. Now, these are extremely immersive battle games. They depict real life battles or real life wars. They use all of the weaponry and all of the military gear. A goal of these games is to be as realistic as possible. And being realistic, they are going to take things from the real world, things where other people or depictions or images where third parties might own intellectual property. And the question is, how do you use things? How do you depict the real world without having to license everything that exists in the real world? Again, these are incredibly realistic video games if you have played them, if you have children who have played them, if you've watched people play them on Twitch, if that is something that you decide is entertainment for you to watch somebody else play video games. Who would have thought that would have become an industry maybe for another podcast? But right now, we're talking about you can see if the soldiers in Call of Duty are growing a beard or need a shave, are sweating. You can hear them huffing and puffing as they breathe, as they run. You could see dirt spattered on uniforms, among other things. So again, we're really trying to completely, again, immerse the player, and players are demanding that level of immersion in their video games. Call of Duty is one of the most popular video game franchises in the world, with over 130 million units sold, according to the information that I found. Think about the money at stake then in a single video game line. It's up there and, in fact, surpasses even the largest movie franchises. So there is something at stake here. Now, on the other side of the case, we have AMC General LLC. That is the licensing company for the all-terrain military vehicle we know as the HUMVEE. And we're talking about the military one. We're not talking about the one that's for personal use. So this is the HUMVEE that you have seen, or maybe if you have served in the military, certainly driven or ridden in one. It's the kind of thing, as soon as you see it, you know what vehicle it is. What kind of IP are we talking about here? We're talking about trade dress in the overall configuration or appearance of, in this case, it would be goods or services. Here, the good, if you think of it as a good, I assume that they are purchased, at least by the military. We're talking about the overall appearance of that HUMVEE military vehicle, where it has a certain look. There is only one source of the look, and that is the creator of the HUMVEE. Now, interestingly enough, or an interesting part of this case, is that AMG, or AM General, the company that was asserting rights, is the licensing entity. So they take the HUMVEE name and appearance and license it for different uses. What are the different uses? For example, one of the different uses could be for toys, or one of the different uses could be as a model. So those are the type of things that AMG might license it for. It'll come up in the case AMG did not license it for video games. It turns out to be important. Now, how is the HUMVEE used in the Call of Duty video games? Well, players can find them. Players can ride on them for several minutes during a quote-unquote scene of the video game. They can assume control of the HUMVEE. They can assume control of the turret-mounted machine gun that is on the HUMVEE. So there's certainly a lot of gameplay involving it. It also appears in some of the trailers for the games, and it is part of a strategy guide for the game. Now, AMG claims that by using the HUMVEE without permission, that the video game company violated their trade dress rights in the HUMVEE, or the rights they had to license in the HUMVEE. So we get to the New York court, and it is essentially a trademark case. So when we say trademark, trade dress is a kind of trademark, but trade dress is an overall appearance of either packaging or the product itself. We're going to talk about this more in other IP Goes Pop podcasts, but trade dress in the product itself, which is referred to as trade dress product configuration, can be more difficult to prove. And in this case, it was more difficult to prove. What's interesting here is the starting point for the New York court was the artistic expression and the protected speech rights under the First Amendment of the video game maker to depict a real world, in this case, military terrain vehicle as part of the game. And here they look to the famous case, which we actually discussed before on IP Goes Pop in season 1, episode 8, on the Hollywood and Wine IP and right of publicity episode. We discussed a case called Rogers v. Grimaldi, another case out of New York, Second Circuit in 1989. In that case, a movie was depicting a character that was similar to the famous dancer Ginger Rogers. And in that case, the court held that there was this balancing test, and it was a balancing test of trademark interests on the one side and First Amendment speech interests on the other side. And in that case, it overrides a trademark claim, if you will, where it has artistic relevance in the work, and if it does not explicitly mislead consumers. So there's this test of, are you using this in artistic sense? And it's not that high of a threshold. And are you using it in a way that misleads consumers? So are you using this trade dress in a way that is somehow saying, hey, we're sponsored or licensed by the people who make the Humvee? Well, in this particular case, the court found right away, or in the beginning of the case, that there was an artistic expression in video games. Now, this is obviously going to be important for video game makers. And I'm sure if you talk to video game makers, they will tell you that they, in fact, are involved in artistic form of expression. It's an artistic work. A lot goes into it. In fact, look at any modern day video game. It is very cinematic in scope. It is not just pixels, and it really is part of an overall artistic expression. So what the court said here was, featuring actual vehicles used by military operations around the world in video games about simulated modern warfare surely evokes a sense of realism and lifelikeness to the player who assumes control of a military soldier and fights against a computer-controlled or human-controlled opponent at a variety of computer-generated battlefields. So artistic relevance was found here for the use of it. Now, I'm not sure why there wasn't a fair use analysis in this case. Perhaps the court didn't need to get there. But they looked at the second prong of the Rogers test, let's call it, and they looked at whether it was misleading. Here they look to the likelihood of confusion factors, which are a set of 10 or so factors that determine whether use of a trademark or trade dress is confusingly similar to the owner's use. So it's things like similarity, strength of the mark, trade channels, the price of the goods, how the goods are depicted. One thing important here the court found was, as I mentioned, the licensing company didn't license the Humvee appearance for other video games. And therefore, perhaps consumers wouldn't necessarily believe that the owner of the Humvee sponsored or licensed the Call of Duty video games. It was just used for a realistic battle. So another quote from the court's decision, which really shows you the thinking of the judge in this particular case, where they were not convinced that there would be some kind of misleading use here. They said the defendants have offered a persuasive explanation. The uses of the Humvee in the Call of Duty games is to enhance the game's realism. And in that case, without actually saying fair use, I think there is a type of fair use analysis that went in here. So to summarize, realism outweighed the potential confusion, particularly where consumers would not believe that the appearance of the Humvee had to be licensed. And in that case, ultimately, Activision prevailed, and the Humvee can appear in Call of Duty without them having to take it out or perhaps pay some licensing fees of some kind. So as video games get more and more realistic, there will be more of these kind of clashes of the real world versus the video game world. Another interesting case, also from 2020, actually decided March 26, 2020. This case is called Solid Oak Sketches, LLC versus 2K Games, again, out of New York, out of the Southern District of New York, decided March 26, 2020. And this case is about the NBA game, the 2K, NBA 2K, which comes out every year. It's usually a big deal which of the NBA players is depicted on the cover. It's also a big deal just to be part of the game and to have certain stats and things. Well, this particular case isn't about all of that. Clearly, it sounds like I want to play this game, but I have to be very careful with my video game use, as it will probably take up all of my time and certainly my podcast recording time. In this case, the players were as follows. There was Take-Two, a major developer, publisher, and marketer of interactive entertainment and video games that develops and publishes through its wholly owned subsidiaries 2K and Rockstar Games, including the NBA game, NBA 2K, with incredibly lifelike depictions. And every year, if you go back through all the, from NBA 2K12 to today, you will see every year it getting more and more realistic, from the players' moves to the depiction of their celebrations after making certain shots. When Seth Curry makes a three-pointer, he may have a certain celebration. When LeBron James dunks, he may have a certain celebration. All those things, again, bringing the realism, bringing this lifelike immersion into the game so the players really feel part of it. And again, today we're on IP Goes Pop. We're talking about two really well-known franchises. Call of Duty, which is going to have fans for every different variation of it, or every different version, or every new one that they release. And NBA 2K, people wait and cannot wait until they release every new version. So on the other side of this case was a company called Solid Oaks, which has the licensing rights to the tattoos owned by various players. So we're talking about another part of NBA culture. I would say that the player that really put the tattoo culture into the NBA was probably Philadelphia's own Allen Iverson, AI. And again, when people think of this, they also think of Dennis Rodman and his many different tattoos and depictions. And the art that is depicted on those players' bodies really becomes part of their image and part of their likeness, which will impact this case as well. Little foreshadowing here. So here are some of the tattoos that were at issue in this case. There are three players with varying tattoos. So first was the LeBron James child portrait tattoo, which was based on a baby picture. That is, again, if you watch NBA games, you may notice these tattoos or have seen them. Then there was the LeBron James 330 and Flames tattoo, which is actually a depiction of his Ohio area code 330. There's the LeBron James script with scroll, clouds, and doves. These are just summaries of the tattoos that the court made up just to describe them. And then the next player was Kenyon Martin. He has a wizard tattoo. And the other player and the tattoo at issue was Eric Bledsoe's basketball with stars and script tattoo. And here, the company that owned the rights to the tattoo licensing said that the video game company infringed the copyrights in those tattoos by depicting them in the NBA 2K14, 2K15, and 2K16 versions of the video game. And here, what they're basically saying is, hey, you're taking our artistic work, and even though it's depicted on the players, you are still getting the benefits and use out of it. And for that, you should have to, in some way, compensate the artist or compensate the company that owns the license rights to the artist. So here we're really talking about a copyright case. And there is a fair use component here, but I want to talk in this episode about two parts of this, which come up a lot in different copyright cases. One is called de minimis use. The other one is called implied license. So looking into how the tattoos are used in the game, even though the players are depicted as they are in real life, and in real life they do in fact have those tattoos, the court said, well, let's look at how the tattoos actually appear in the game. So in the game itself, the tattoos do not appear separately. So they are not part of the artwork, if you will. They're not used separately than the players' bodies. They only appear on these particular players, which are 3 players out of 400 available players you could choose when you have the 2K video game, the NBA 2K video game. The court stated that the tattoos comprise only a quote unquote minuscule proportion of the video game data. So the way the video game company positioned this case, they said, look at all our software and our lines of code. We're talking about 0.0003% or so of all of the data involved in the games. And then they said, let's take a look at how prominent the tattoos appear. Well, when they're on their computer screen, they are no more than 4% to 11% of the size they appear in real life due to the great distance of the virtual camera views of the players as they play. So you could see, at least in the background of this case, the court is setting it up for kind of a de minimis use, which is from the Latin, meaning from the smallest. De minimis use really means you are taking only a small part of a copyrighted work, a part that's so small that it is not considered to be copyright infringement, or this is a defense to copyright infringement. To establish that infringement of a copyright is de minimis and therefore not actionable, the alleged infringer must demonstrate that the copying of the protected material is so trivial as to fall below the quantitative threshold of substantial similarity, which is always a requirement for actionable copying. Of course, I'm reading from the case there, just to give you some background of the test for de minimis misuse. So in a copyright case, you have to prove substantial similarity. If it's a small part that is being taken that is trivial, it doesn't become substantial, if you will. So for the de minimis analysis, we look at the amount of the copyrighted work, the observability of the copyrighted work. That is the length of time the copied work is observable in the allegedly infringing work, and factors such as focus lighting, camera angles, and prominence. So with those tests, for example, let's say you are filming a movie and you're just walking down the street and you can't block out everything on the street. You can't block out every car. You can't block out every store sign. If you are not focusing on those things, you have an argument that there is some kind of de minimis use of the backgrounds. Here, they're saying there's de minimis use of the tattoos. And the court found, as a matter of law, that the copyright claim would be dismissed because no jury could find that the tattoos, which only appear very trivially on only 300 or 400 players, was copyright infringement. You know, it was such a small amount of the game. It is such a small amount of the player as depicted in the game that the court simply didn't see that this rose to the level of an infringement. Now, the court also looked at implied license. And an implied license kind of is one of those things in the law that is what it says. It's you get a license to one thing, and by implication, you get rights to something else. So, through all of the licensing provisions, and I'm sure it's very complicated to go through, of the NBA and the players, NBA 2K gets a license to the players' likenesses. And that is a license that they, I'm sure, are compensated for, so they get all of the players as realistic as possible. And they have a right to depict the players and their likenesses in the game to make it real. This is in part of the realism. The court stated that if you have a license to the players' likenesses, then by definition, you have an implied license to what appears on them, if you will, in this case, a license to the tattoos. Now, there was also an extensive fair use analysis, which we are going to go into fair use, particularly in our music episodes that are coming up. But certainly, fair use was an important part of this case as well. However, the video game company had already won, if you will, under the de minimis use and the implied license. Now, there's another case that is going on and is actually proceeding through the courts of another tattoo artist with tattoos for, in this particular case, they are tattoos on, again, LeBron James. He appears to be a nice canvas for the tattoo artist's work. And also Philadelphia Sixers' own Danny Green and Tristan Thompson. So they are at issue. Their tattoos are at issue in another case. That was not dismissed. And in that particular case, the case is moving through the discovery phase. But we'll keep an eye on it, and I'll report back on IP Goes Pop if anything interesting happens. But I think it really summarizes and puts the point to the subject matter of this particular episode, that when you start to depict things in the real world in a virtual world, we are going to have more lawsuits and more people saying, hey, I created that. That's my intellectual property. That's my copyright. That's my trademark, my logo, my design. You're using it in a video game. And as the artist, I should be compensated. So again, to start off this season of IP Goes Pop, two really interesting cases. Certainly, in our introduction for IP Goes Pop, we always say that it's about the interface between intellectual property and pop culture. Here we have the interface between reality and virtual reality, video games, real life, coming together. And as long as we have realistic video games, we'll probably face issues like this. We'll be talking more about video games this season on IP Goes Pop. We'll be talking about music, television, movies. Please send us an email. You can send it to me at msnyder, MSNYDER, at vklaw.com if you have any topic of interest. So when you are playing your more realistic video games, keep in mind that there are real world issues, some of those legal, some of those just fun. But I would say enjoy. Perhaps for the holidays, you received a new PlayStation or an Xbox, or when your kids are away, you are practicing so that you are not as bad at the video games as they think you are. But for this episode of IP Goes Pop, this is Michael Snyder, and we will see you soon at the movies, watching TV, or listening to music right here. Thank you.
The IP Goes Pop podcast series is created and produced by Volpe Koenig, an intellectual property law firm based in Philadelphia, Pennsylvania. Visit us at vklaw.com.